Hi, Tania. Welcome to the show.
Hi, Venu. Thank you so much for having me. It's a pleasure to be here.
Okay, on the day of arbitrations, when you have to meet clients, do you wake up early? Do you have some mode of preparation that you go into?
So, I have always been an early riser, and I feel like my energy is at its peak in the mornings. And so, I like to take that quiet morning time to prepare for my meetings and to also have a clear understanding of what my objectives are from the meeting itself, because I work with a variety of clients, and no two meetings are ever the same.
Absolutely. And in a world of distractions, which is practically every second, how do you manage to focus?
It's so much more challenging now, and I feel especially when you're a lawyer because of all of the volume of documents that you handle and the nature of the cases that you handle, that focus is probably your most important currency. So in terms of what I do, I like to keep my phone away and just leave it off to the side and not worry about it. And the other thing I like to do is pause my email notifications for, maybe half an hour or an hour at a time, just so that I can have that concentration period and focus on what I'm doing.
Great. So the way you do it is just keep everything at bay and then say you'll return it to it at some point in time.
I'm only
Okay.
human.
So this is my first job podcast, and today I have a person who is highly qualified and has an off the beaten career track journey. Arbitration law is an alternative dispute resolution method to resolve legal issues between companies, governments, and even countries. So the parties involved agree to have a neutral third party who's an arbitrator to help make a binding decision on their conflict instead of going to court. Tania Singla specializes in international arbitration and she helps resolve disputes outside the traditional court system. She has first hand experience of handling complex and high value dispute and has worked with leading international law firms in Frankfurt, Geneva, and Paris. She is currently based in Dubai and, apart from her job, loves to teach courses on arbitration and advocacy at universities and collaborate on high impact projects with people from different backgrounds. My name is Venugopal. I head Ideascape, which is a company into branding, creative, and design. And every week I go and talk to people who uh, have their own wonderful career journeys, which is full of twists, turns, and they have so many insights at the end of it. And all I have to do is ask them questions and listen. So, Tanya, how did this whole thing of getting into arbitration law come about?
Thank you so much, first of all, for that very kind introduction, Venu. It's really nice to be able to share my experiences with you. In terms of how I landed on arbitration, I honestly want to say this from the outset. I did not have a plan for my career. I think every time I plan something, I end up going in a completely different direction. And that, I think, is a gift as well as a curse. But in terms of arbitration, this started when I was in law school, and initially I thought I would want to specialize in intellectual property. And so, to give you a little bit of context, as lawyers, we obviously learn the law, but there are so many different practice areas of law. It's like being a doctor. So when you do your MBBS, it's like a general practice that you learn. But then you move on to specialize as a neurosurgeon or somebody who works with kidneys and different parts of the body. So just
Right.
like that, as lawyers, we also specialize in different practice areas. And so the one that I thought I'd be really interested in was intellectual property law. And I had started to sort of specialize in it. But then I did some work experience in it and I realized that I enjoyed the theory of it, but not so much the practice. And I realized that I didn't want to spend the next 30, 35, 40 years of my life doing intellectual property.
Right.
And it so happened that I participated in this moot court competition that was based on arbitration. And it was a complete chance that happened for me. And I think it was just love. I think it became a passion so quickly that I decided to specialize in it. And when I finished law school, I had the opportunity to decide whether I wanted to join a law firm or do a master's in arbitration. And it was quite unusual at the time that I was making this decision to do a master's without work experience. But I decided that, I wanted that strong foundation in arbitration before I launched it to my own practice. And that's what I decided to do. So that's a little bit of a background in terms of how I really
Great.
stumbled onto
No, that's
arbitration.
that's the tone. But did your parents have anything to say, or did they want you to go in a certain direction, or they left it to you entirely?
So I have been very, very fortunate to have parents who have been extremely understanding of my unconventional career choices. But I was really inspired by my parents in terms of the initial career choices that I was making. So the reason I went to law school was because I wanted to be a civil servant. I wanted to be an IS officer, and that I thought law as a foundation of study
Right.
would help me be a better officer. And this was inspired by my father, who was in the civil services. So that's where it was coming from. But when I sort of transitioned towards arbitration and I wanted to do all of these things at the international level, my parents were very, very supportive.
Okay. Okay. And do you remember where exactly your arbitration journey, one of the early, meetings that you attended? Because it's one thing to do it in college. It's another thing when you join a partner. So, do you remember your first job interview and what happened there?
I remember it so clearly. It was, I remember it was a law firm that I really wanted to work at. And I was so excited that I had the opportunity to interview with them. And it's such a funny story because I thought I did really badly at that interview. And let me tell you why. So there were two senior associates from the law firm who were interviewing me. And we had a conversation about my CV and my resume. And we come from very different backgrounds, right? They were based in France and they had a very French background, and I was from India. And there was a distinction in terms of they come from a civil law culture and I come from a common law culture. And so when we were going through my resume and like dealing with questions, I could obviously feel the pressure because I really wanted to work with this firm. But I was doing this in the university library. And at some point, somebody knocked on my door because I was, giving my answers too loudly. And it was in the middle of the interview, and I just completely messed with my flow and I didn't know what to do. But all I could do was, smile and I say that, I'm here for you. Let me repeat my answer. And I think they absolutely loved it because they smiled at each other and I got an offer the very next day. So it's funny how things work out. And I was so disappointed that evening because I thought I had done very, very poorly and no one's ever going to look at my resume again. But it's all of the little things that matter, and just keeping your calm in the midst of all of that pressure that makes a huge difference in terms of how you come across as well.
Okay. Now, let me come at this from a different direction, which is that people tend to think of legal matters and arbitration, especially, as being very dense. It's not
Right.
easy to understand because it has a lot of nuance, and these things have to be teased out from language, which itself is not very easy to follow. So, how is it that you found your footing there, and how did you manage, or was it an interest that came from within? Because there's no other explanation really.
So, ever since I was little, I have really enjoyed solving puzzles. And so, when I stepped into the world of arbitration, the density that you're talking about seemed like just another puzzle to me. Until date, every arbitration matter that I approach, I know that it is solvable, and it's a matter of finding that key that is going to solve it. And there's a lot of hard work involved. Don't get me wrong, right? Because we are dealing with a lot of voluminous documents. We are dealing with multiple parties. Often we are dealing with multiple laws that are applicable in that scenario, and that often tends to make international arbitration matters quite complex. And the stakes are very high because I've dealt with claims that have ranged from anywhere between $25 million to $5 billion. And so there's a lot
Wow,
that you have going on for
at
you.
stake. Yeah, yeah.
Exactly. But I think that with international arbitration, you need to have a very strong foundation of the procedure because international arbitration gives you an alternative procedural framework, which is unlike the court system that you have. And at the same time, you need to have a very strong understanding of the law that you're dealing with, because that's how the dispute is going to be resolved. So the density and the nuance that you're referring to, it surely exists. But to me, it didn't seem like density. It seemed like fun. And I think that is why I enjoy what I do so much.
Okay. Wonderful, Tanya. And there is something that I saw from what you had written on LinkedIn, which I think is a wonderful template for people who are entering the legal profession or any profession for that matter, because it bridges a huge gap. What do you do on your first year on the job? How do you understand what your job is about? Could you tell me about the LinkedIn series that you created and why you did that?
Of course, it's my pleasure. So, the LinkedIn series that I created is called What Your Partner Wants You to Know. And this is a series where I would share my insights and my practical experience based on what expectations a law firm partner would have from their associate. Because when I started working with an international law firm in Paris, I realized that I was part of a really big team, and there were about 14 partners at the time, and about 30 associates, and that's a really big team by Paris standards when you're referring to just arbitration.
Right.
And I was very lucky to be mentored by some very, very amazing partners at the firm. But at the same time, I realized that when you work with multiple partners, everybody has their own working style.
Right.
And when you are a first year associate who's just stepped into the world of law firm, there are so many aspects that come into play that nobody really tells you about. And when you're coming from a university background, where your expectation is to be taught everything, then there is a very high chance that that gap of absence of information regarding what is expected of you can also impact your career trajectory within that law firm, because there are some people who pick it up very intuitively, right? But there are some who would do very, very well if these expectations were communicated to them. And so I had a little time and I wanted to figure out how I could share this. And LinkedIn seemed like a great option to do it, because I had connected with a lot of students and a lot of junior associates during my time as an associate in Paris. And I wanted to put it out there for anybody to be able to access at any point in time, because you might be an intern today and you might be an associate tomorrow, and maybe you want to come back and you want to be able to look at it and think of it as a way of somebody who's 1 or 2 years ahead of you sharing their experiences with you, and you are able to use that to shine in your law firm, because not everybody knows about what your partner wants you to know, but you do, and
Exactly.
that's what can set it apart for you.
I remember a couple of posts from that. The first one that I'll talk about is trust. How do you build trust? You said one partner seems to pick one associate all the time, and all the others wonder why is it that happens. And you broke it down by saying it's trust because that person has been able to, provide the resources necessary and respond to whatever the partner wanted. And over time, they go dependent on that particular person, which is how trust is built. You also spoke about how it is a step by step process and it's like investment in a bank, which I think is a beautiful way of putting it. That trust is not something that, it's not all or nothing. You have to literally earn it one step at a time. And every time you let someone down, maybe a bit of that trust breaks away. And I like the fact that you spoke about not trying to impress the partner, but trying to understand what exactly they were looking for. Because these are the mistakes that people make on their first days or weeks on the job, thinking, but not everyone does this thing of examining themselves and saying, what am I learning? And then
Right.
be able to articulate it, which I think is the more difficult part. It's one thing to go, understand, internalize, and start working. It's another thing to say it and put it out there so that people can follow. So, what I think you've done is a marvelous template for any job that people get into. It's a wonderful way to start and understand. And you wrote about it, which I think is something I keep telling people, write,
I mean,
because
especially
that's
when
the way
you
you.
think about something like trust, right? Because it's not a
Right,
conversation that someone's really having in terms of how you can build trust. And I feel like
right,
when you are working in any kind of law firm, there is a lot of pressure on you to be brilliant. And I
right.
think this is internal pressure that you create for yourself. And it takes time to understand that when you're working with a partner, they don't necessarily need you to be the smartest associate in the world, but they do need you to be reliable and somebody that they can trust. Because if they
Yes,
have sent an email to you, they need to know that it'll get done, and they don't have to follow up with you just because they don't have the time for it. And I think that is
right,
why that element of trust is such a key factor in,
right.
and it can only be built through consistency. And that was the point that I was making in that post. It's actually one of my favorite posts from What Your Partner Wants You to Know as well.
Great. So, can you give me a couple of examples of your days on the job and which were some of the cases that have imprinted themselves on memory? Because on your memory, because without obviously having to disclose what it was, who are the parties involved, at least as a case.
So there are actually two cases that I can think of. The first one I did when I was working with the law firm in Geneva, and this is when we were doing an investor state arbitration, and I had the opportunity to do the hearing in Paris. And the reason this case is imprinted on me is because the team that I worked with was fantastic. It was a mixed team of senior partners and counsel and junior associates and mid level associates. So it was a big team of about 8 people. And I was supporting the team as an intern. And I, at that point, was staffed on the case extremely last minute. So, and when I say last minute, if the team was leaving for the hearing from Geneva to Paris on Saturday, I was asked to join the team on Friday. And that meant that I didn't have any substantive background about the case, but they needed urgent assistance. And I said yes. And I think that's the probably one of the most important yeses I've said in my life. And because I didn't have the background, I had so much opportunity to pay attention to the advocacy that is being done and look at how arbitration hearings are conducted, but from a completely fresh lens. And so I didn't have to unlearn anything from any kind of baggage that I had from previous practice. And I saw how some of the best lawyers in international arbitration were putting their case forward. I learned how to interact with different kinds of arbitrators and work with institutions. And I think that case left a huge impact on me in that sense. Um, the second case that I will talk about is a case that I did when I was an associate at the international law firm in Paris. And this is when we were working with in house counsel, but of a government entity. And we were dealing with certain sensitive assets that were based in the Middle East and North Africa that were impacted by civil war. But the reason that I really enjoyed this case was because, on one hand, I worked with offices, different offices of the same firm. So I worked with associates from New York as well. And I worked with associates from London, and I worked with associates from Madrid. And at the same time, I had a lot of opportunity to interact directly with the in house counsel who were working with us on this matter on behalf of our client. And it was really impressive to understand the in house perspective of it. Because when you are in a law firm, you are so focused on the legal aspects of every matter, and you're focusing on
Right.
the legal interests of your client. But from that case, from working with that in house counsel, I realized how business interests also impact the legal work that we do. Because, we could have developed the best legal strategy in the world. But the question is whether your business executives have the appetite for that kind of a legal strategy, because it will directly impact maybe the publicity that they will go through if we launch that legal strategy. And so I think there was an evolution in terms of my strategic perspective, in terms of looking at what kind of interests do I need to consider based on the type of client that I have. And you realize that one size fits all approach does not work in international arbitration.
Okay. Great. So we'll just take that short break. I'm talking to Tania Singla, who's an international arbitration lawyer. And in the previous segment, she spoke about how she got into arbitration, how she found that from the various legal streams available, this is what she took to and understood would be what she was interested in right from the beginning. She did something very sensible, very early on, which is she wrote a series of posts on LinkedIn after she got her first job, which is what your partner wants to know, which is how do you function as an intern and how do you function in a company that you've joined recently. And the wonderful part of what she's done is that those principles apply not just to law, but just about any profession that you're entering into. And it's a template for how do you go about building trust? How do you make yourself useful? How do you make yourself valuable? She spoke about how she got into the thick end of arbitration because she was working with wonderful teams across the world, and she understood the importance of being able to deliver in a very short time frame and to be able to grasp at what the team wanted her to do, which I think is one of those things that takes people time to understand. In the next segment, I'll be talking to her about um, what starting salaries are, what the career track is, and what are the things that she enjoys about the profession. So, if you like what you've heard so far, subscribe, share, tell people about this because the whole idea is to say that this is something that people should benefit from. So, Tanya, what are the things that in terms of salaries, was that ever a consideration, or did you say that yes, that's important, but what were the most important aspects of how you looked at a job?
So I would say that salary is an important consideration for everyone. But I think because I was starting out so early, I was very clear in terms of the kind of setting that I wanted to work in and who I wanted to work with. So, to give you a little bit of context, in arbitration, you have a lot of different environments that you can choose to work in. You can choose to work with an arbitrator directly, you can choose to work with an arbitral institution. You can also work with law firms, or you can work with different media houses that report on international arbitration as well, or you can choose to be a professor in international arbitration. So when I was making this decision, I was very, very clear that I wanted to advocate for parties and I wanted to be counsel in international arbitration, which is why a law firm made complete sense to me. And when I chose the law firm that I work with, I think it was mutual choice. They chose me as much as I chose them as well. And that made all of the difference because at that point I was not particularly focused on salary. What I wanted to do was work at one of the best law firms in the world and be trained in a very, very intense work ethic. Because I think having that training at an early stage in your career is what you take with you no matter where you go. And now that I've moved to Dubai, I can feel how that training impacts everything that I do and makes a difference in terms of the perspectives and the results that I'm able to bring for my client. So, salary, I want to be very honest, was not a particular consideration at that point in time. It was more about the opportunity to be in the room with the right kind of people and the opportunity to be in the right room where I could have a seat at the table and see international arbitration being practiced in the best way possible.
Okay. You worked in several countries, Dubai, of course, and Frankfurt and Paris. What is the difference that you've seen in the work culture in these places?
In terms of work culture, I think there are very, very important distinctions that you would see across Germany, Switzerland, France, the Middle East, and India as well. And I think some of it comes down to the value that people attach to local training. Like, for instance, when I was in Germany, there was a lot of emphasis on local laws and grooming local lawyers in a certain way and international lawyers in a certain way. And there was a lot more focus on dealing with the text of the law and thinking in a very, very dimensional fashion about how we want to approach the particular case. When I was in Switzerland, the work culture was very interesting in terms of the holistic approach that they would take to dealing with a case. And there's no right or wrong here, right,
Yeah,
in terms of work culture.
right.
But there was also a lot of emphasis on being present for your family and not doing unnecessarily very long hours, which I thought was a very interesting development because law is a difficult field to be in and it can be intense because long hours are a part of the job, and that's something that
Right.
comes with it. And Paris, again, it was a different ball game altogether. People were so nice, and it was really nice to be able to interact with people from a diverse set of backgrounds. And everyone practiced law with a different perspective and a different working style. And so you quickly learn to adapt to like different working styles. Some people prefer to do certain things over an email. Some people prefer to like pick up the phone and just give you a call and like discuss it. And to the millennial
Right.
version of me, it just seems so strange, like somebody just gave me a call, like they're not texting. But that's how you figure out different work cultures. And in
Okay.
Dubai, like, I mean, I have been having this conversation with some colleagues where I think the way international arbitration is practiced in Europe is so different from the way that it is practiced in Dubai. And there are all of these little nuances. For example, you don't need a power of attorney from your client in Europe to represent them. But in Dubai, you need a power of attorney, a litigation power of attorney from every client that you work with before you can represent them in any forum. And it's all of these little things that you quickly realize in terms of how things are done differently. And I love that about my background and my experience. It's such a privilege to have worked in different countries because I think when I work with a German client or I work with a Swiss client, I have a certain understanding of local culture,
Right.
and that sort of makes it unique for me. And I've been pushed out of my comfort zone so many times that at this point I don't believe I have a comfort zone anymore. The world is my comfort zone.
Yeah. No, that's a wonderful place to be in because it's one thing to see culture from the outside without being involved in it. It's another thing when it becomes part of your daily routine and you have to switch on the fly. So let's say you're talking to a client in Dubai today and you have to make a call to someone who's in Switzerland. And one of the things that you instinctively learn is to switch gears, not just mentally, but culturally,
Oh,
which I
absolutely.
think is a, like you said, you know what seems to work better locally because you have actually worked there. And these are the things that I think AI can't train you on. But okay, that's a different conversation. We'll get there at some point. So, is there something that you have found helps you take a meeting forward? What do you do before you start a meeting? Do you listen more and then start contributing, or do you lead with a conversation?
So, in terms of a general meeting that I would, for instance, attend with a client, it would, because I'm an associate and I would generally be attending that meeting either with a senior associate or a partner. It is typical for the partner to take the lead, and then we offer the stage to the client so that they can tell us about the issues that they're facing, so that we have a very clear understanding of what kind of solutions we might be able to provide. Because there are times where clients approach us where they need a legal solution, but sometimes they need non legal solutions as well. For instance, if you are somebody who's a director of a company, and then you want to understand how you can do something at the next shareholders meeting so that it will not negatively impact your litigation. Um, that's where we also come in. So, in terms of working with clients in meetings, my tendency is to listen more because of the level that I'm at, and I'm also gaining experience through that process. And where my contributions really come from is with respect to legal strategy, because that is a conversation we are having as a team. That what would be the best legal strategy that can be adopted. But at the same time, I'm also the one who's closest to the documents. So I would be the one who has an understanding of what documents we have received, what is the information that is already available to us, based on which we are formulating our current legal strategy. And things evolve, because there are times where clients are able to discover more documents and they send it that our way, and that's when we revise our strategy and we figure out what we need to do. But in terms of my general approach during meetings, I'm very active. I'm somebody who would be taking notes constantly because it keeps me focused. And I would have that conversation with clients if I need to step in. But generally, the lead is taken by the partner, and I'm there to assist in any capacity that I can.
Okay. This comes from a different sort of point of view, which is Any dispute, people have two widely varying perspectives.
Right.
Both of them feel that they are right, that they have a point of view and they have supports for that particular point of view. So when you're arbitrating things between them, in a sense, it's a compromise, though that is never the word used, because no person can get 100% of what they want,
Right.
and you have to find what is the median. How do you figure that out?
So, in terms of figuring out the median, it's a very interesting exercise that I think arbitral tribunals have to go through, because you are absolutely right. Every side and every client that I have worked with is convinced that they are absolutely right, and in that sense, it's something that arbitral tribunals need to navigate based on the quality of the advocacy that they receive. So, advocacy plays a huge role in terms of helping arbitral tribunals make that decision. But that median becomes a critical factor because you want both parties to be satisfied with the outcome and not necessarily want to have a huge appellate procedure, which is why parties often don't want to work with court litigation, because you have multiple rounds of appeal that you're going to go through. So, if you want a binding decision, you ideally want both parties to be satisfied with the outcome. And the median has to be justified by what the law provides. And at the same time, it has to be something that needs to be figured out based on the practicalities of the case. So, when arbitral tribunals are often dealing with these matters, they will look at it from a perspective of what does the law allow a party to do. For example, if you're dealing with a breach of contract and it is very clear that one party did breach the contract, then you can't really have a median because there is a party that is right and that is wrong. But when it comes to something
Right.
like awarding legal costs, then in those circumstances, you might have a situation where, you know, based on the cost that the parties have asked for, as a successful party, you might receive maybe 50% of your costs or 60% of your costs. So there's a place to arrive at the median, and there's a place where you cannot arrive at the median. And what you can do is ensure that you are giving the fairest outcome that you can to the parties.
Right. It's interesting that you resolve disputes before they get into long drawn court battles. So it's one of those things that helps to take the load off courts and also helps to settle things before it gets out of hand. But do you have a sense of where this is going to go early into the process or midway through the process? Give me an instance of where you were surprised by the way things turned out rather than it going in expected directions.
So I think with respect to arbitration matters, it can be difficult initially to really predict what the outcome would be because there are so many variables that are involved in the process. The variables would come in the form of the law firm that the other side has hired. It would also come in the form of the arbitrators who are on the arbitral tribunal and what their background and training is. It'll also come down to the kind of resources that your client has to provide the right kind of documents that you would need to make your case before an arbitral tribunal. And so, when with all of these variables present, I feel like there are times when I go into an arbitration hearing and I cannot really predict how an arbitral tribunal will decide. There are some times that you can with slightly smaller cases, but when there are high stakes involved, you really do not know how an arbitral tribunal will necessarily find. You can hope that you have done the best job that you could possibly do and they will find in favor of your client. But there are a lot of aspects that an arbitral tribunal has to look at because they're looking at both parties as opposed to you who's representing only the interests of your client. So that makes a
Right.
huge difference in terms of what you would expect as well. And you realize that once you have done everything you could possibly do, you essentially, the ball goes on to the other court and you just have to wait for the decision. But in terms of a case where I think things went very, very differently, there was actually this matter where when we started working on it, I thought that we wouldn't be really be successful because we were the investor against the state. And I thought the state had a very, very strong position in terms of their policies and what they had been able to do. And I think That is why arbitration can always surprise you. And over the course of period, through a lot of research, through a lot of connections, through a lot of information, we were able to build a very, very strong case for the client. And ultimately, the investor was able to win in that particular arbitration. And until I read that award, I couldn't really believe that that was the outcome that we had managed to achieve, because I was convinced at the beginning that this is the case that we were going to lose. And I think that is one of the beauties of international arbitration, that you can always be surprised by what goes on during the case in terms of how the variables evolve.
Yeah. What I find fascinating about this is that while the arbitration is between individuals, between companies, and between governments, ultimately they are all represented by people.
Right.
So while the state could or the country could appoint a couple of people who represent the case, the state's interests or the country's interests or the company's interests, it's a group of people talking to each other, because it's not as if the country is speaking by itself. It's like there is a definite, so there's a lot of personal dynamics involved. Do you think that plays a major role, or have you seen that that takes a back seat depending on the gravity of the situation involved?
So I think when it comes to international arbitration, because of its international nature, so much of arbitration comes down to relationships and personal dynamics. At least that's what my experience has been. So in the international arbitration community, it really doesn't go down to, let's say this is the Indian legal community, or this is the Asian legal community, or the European legal community. It is
Right,
international. And which is why there are so many international events that are conducted every year for arbitration practitioners from all over the world to meet each other. And we call these arbitration weeks. So Paris has its own arbitration week, Turkey does one, London does one, New York does one. And the idea is that you are able to form relationships with other practitioners from all over the world, because you never know when they are on the same side as you, because we sometimes work with co-counsel as well. They might be on the other side representing them as counsel, or some of the more senior arbitration practitioners could tomorrow be an arbitrator on one of your matters. And so that has actually been my biggest takeaway as an arbitration lawyer, that relationships matter and personal dynamics play a huge role, because you're right, like it's people talking to people, and these are people who are trying to achieve the best outcome that they can for everyone involved. So, in that sense, I think it becomes so much easier to navigate a tough case when you have people that you can professionally work with and that you get along with, people who are reasonable, who are adaptable as well, and who maintain a certain level of, civility and collegiality, because not everything needs to
yeah,
be, contentious.
yeah,
And so,
exactly.
leading with that idea of, today we are on opposite sides, tomorrow we might be on the same side, or tomorrow we might be an arbitrator. These variables create a huge dynamic where you know that want to you want to collaborate with people and bake that into every matter that you're working in. Because I'm not a fan of aggressive lawyering, I find that unnecessary. But I'm a fan of, having a very clear determined idea of this is what I want to achieve for my client, and then working and collaborating with the other side to achieve that outcome to the extent that it's possible for both parties.
Great. So I'm talking to Tania Singla, and in previous segment we spoke about salaries and what are the career tracks which are available to them. And Tania was very clear that learning was a very important part of what she saw. While salaries were important, the other aspect was to understand cultures and to understand work environments and to understand the legal systems in various countries. And she spoke of her experience as to how in Germany it was she had to learn a lot about the local culture and the laws and the way people interacted in different cultures, whether it was in Paris or Dubai. And she made particular mention of how, let's say, even small little processes like getting a sign off from the authority. Okay, I forget the exact word that she used. She also spoke of what it was like to deal with people representing countries and companies and individuals, and what are the various considerations. She spoke of what an arbitration meeting was like and how it was going into one of them and understanding what are the processes involved and what the possible consequences could be. In the final segment, I will speak to her about what the career tracks in arbitration are, what are the kind of things that are required for getting into arbitration and building a career in this. If you like what you've heard so far, please share, subscribe, like, and let people know, because that's the idea why we're doing this show. Okay. So, Tanya, where does this go in terms of a career? You, of course, you get to be a partner over time, but that's a change in designation. What do you think you actually learn over the course of 8 to 10 years, or 15 years, or 20 years? Where do you think the part of the job that you really love comes in?
So, in terms of what you learn over the course of being an associate and then eventually making partner, I think so much of it comes down to transitioning from being just a lawyer to also being somebody who can bring in business, being becoming somebody who can manage a team, who can manage a project, who can handle administrative tasks. Because I think being an associate, being compared to a partner, is relatively so much easier to do because I have to focus on matters and I have to get the law right and I have to do that. But when it comes to being a partner, it's just so different because you have to work with clients, you have to deal with invoices, you also have to attend conferences and work with different kinds of clients, potential clients to bring in business. And at the same time, you have this group of associates that you are working with who you are managing and who are constantly, there are all kinds of requirements in terms of what associates need. You have to be responsible for their performance as well, and things like that. So, being an associate is what law school trains you for. But I think being a partner is what a law firm trains you for. And that, I think, is the key distinction, that you realize that your work expands so much more significantly when you are a partner. And there's also a lot more accountability that you take on based on the fact that you are now representing the firm in front of clients. And that's that additional touch of maturity and responsibility that you need to be groomed into and have a very, very clear understanding of. And you obviously also become a better lawyer because you have done the reps and you've gone through the iterations where you've worked with different kinds of clients over a span of 8 to 10 years. And you have worked in different legal strategies. And there are certain things that you pick up that become second nature to you. And you can see different nuances so much more easily than perhaps an associate can. So I think that is what those 8 to 10 years before you make partner are all about. And having an understanding that law firms are not just a work setting, it's also a business. And working with it from the perspective of business makes a huge difference.
Okay, so how do arbitration companies get business? What happens? How does the process work?
So, I mean, there's nothing unique to arbitration teams in that sense, but so much of it comes through either referrals or it comes from, people that you have interacted with, relationships that you might have. For instance, in international arbitration, a lot of people have, alumni groups, they have classmates who might be working with certain companies who might have these needs. You might also have classmates who are working with governments. And so, when a need for representation in international arbitration arises, then in house counsel would maybe reach out to partners that they directly have a relationship with, or they might ask for recommendations based on who has specialized experience with respect to a particular area of international law or any particular sector. Because in arbitration, you also have different sectors like construction and finance, and not everybody is specialized in everything. So, in terms of getting business, it can come from multiple sources. It can come directly, it can come through recommendations and referrals. It can also come through relationships that you have invested in over a period of time. And it can also come through different kinds of sources. It can also come from peer sources. So, your partners within the firm might be able to
Right.
recommend you. So that's the general framework of how business is generally received.
How much of understanding of the business is involved? Like you said, if it's construction, if it's finance, there is the legal aspect and there is the business aspect. So let's say you're going in cold on a business that you know nothing about. For example, it's an arbitration in the biotech sector,
Right.
which you may not have previous experience of. So how do you then get around that part of it?
So, when it comes to navigating a sector that we don't know about, my approach generally would be to understand the company's financials and their main areas of working, because I think it's important to understand the market and the sector in which the company operates in, because different sectors have different customs and practices in terms of how they conduct business, and it also impacts the nature of the contracts that they sign. So something that is, perfectly fine in biotech may be frowned upon if you were in any other sector. And I think that innate understanding of the business can be helpful. At the same time, we also work towards understanding what the local presence is, because if you are working with a multinational corporation and they have offices in different parts, they their Vietnam office might operate very, very differently from how their Canadian office does. So having a local understanding, there are often times when we work with local counsel to get that understanding as well. And there are all of these little things, like for instance, I like to monitor my clients, any reports that are come from the for the clients in Google as well. So I would set up these search alerts where anytime there would be something that was posted in relation to my clients or the other side, I would get a notification. And the idea was to keep that constant monitoring and keeping yourself in the know regarding the things that might be impacting your client's business. Because it's not just from a legal standpoint, but also from a business standpoint. Because oftentimes, when we work with clients, we are focused on building a long term relationship. So it's not this one arbitration matter that we are focused on, but we want to be legal and business advisors for whatever needs they might have in the future, with respect to arbitration as well. So that long term perspective has a huge impact on our present day strategy and how we get to know the business, which is why that investment of time makes sense.
Okay. Are you able to figure out, for example, whether, when you get into arbitration, because I think cause generally suggests that before you get into the legal case, it's best to try out arbitration. So, do you manage to make out if that arbitration is something that the client wants to get through quickly in order to proceed with the case? Or do you then set back and then say, okay, are there ways to actually make this happen?
So, arbitration is actually different from other alternative dispute resolution mechanisms in the sense
Okay.
that it's an active choice that a client has already made. Because for you to be able to launch an arbitration, you need to have a clause in your contract that would say that the parties agree that all disputes will be settled by arbitration. So, it effectively becomes a choice. So, if you have nothing in your contract, then the default choice would be for you to go to the local courts. But arbitration is an active choice that commercial parties make in their contracts, because that's how arbitration acquires its force. The very basis of arbitration is the consent of the parties. And unless you have valid consent, then there can't, unless you have that valid consent, you won't have any arbitration. And so that is the distinction with traditional court systems. The reason a lot of courts encourage arbitration as an alternative mechanism is because it allows commercial parties an opportunity to work with experienced arbitrators who might have a better understanding of that particular sector, or of the general legal case scenario as compared to a national or a local judge, because they deal with so many matters. And also, it's the pendency of the cases that makes it really difficult. So if it's a business matter and you're waiting for maybe, let's say, a 2 crore payment on one of your contracts, you don't necessarily want to win a case after 5 or 8 years. You want this to be resolved within the next year or so that when you get that 2 crore payment, it actually feels like 2 crores and not like 50 lakhs in terms of adjusted for inflation. And that makes a
Yeah.
huge difference in terms of why national courts encourage arbitration to a certain extent, because it allows this specialized access to expertise and also faster resolution of the disputes.
Yeah. A few years ago, Tanya, this smart contracts were a big thing. They said that,
Yes.
if there is something that happens between companies on a routine basis, then we can automate that part of it. But I think there have been significant problems with getting smart contracts to work technically, or do you think that it will be the way in future?
So I think smart contracts sort of falls within the same realm of, it's the same excitement that we have over AI these days. And I think that is what we are trying to figure out. But I think as lawyers, one of the things we are so focused on is how much can you trust technology and how much can you delegate to technology in that sense. And that's a conversation that we are very actively having in the international arbitration community in terms of how all of these technological developments, sure, they're efficient, but what is the kind of liability they might have the potential to create if we advise our
Right.
clients to use it. So there are
Okay.
so many law firms that are excited about, let's say, something like artificial intelligence and trying to figure out how they can work with AI. But we have read about hallucinations, and we have read about things that AI can get really wrong. And I think that delta between the trust that you need to be able to delegate it to AI, and the fact that it still needs to be reviewed by a human lawyer, there is this difference where law firms are still struggling to delegate to AI 100%. And something similar was happening with smart contracts where companies were getting into it, but in terms of enforceability, what kind of issues might have arisen. And so when it comes to technology, lawyers want to adopt technology because it makes our life easier. It reduces the amount of hours we have to spend on the job. But
Right.
that element of trust is because reputation in law is everything. And once you sort of lose it in front of a judge or a client, it's a huge loss, and you don't want to take that risk at any point in time.
But you're right. And maybe the other thing about smart contracts is the enforcement aspect. Because let's say you built the financial aspect through by ensuring that the money is committed and it's available. So when you complete a certain stage, the money is paid. But let's say there is a breach which needs to be enforced. And at that point, I think the software will give up because I don't think that there's a way apart from sending out reminders or telling people that this needs to be done.
I think
So,
there are actually a lot of interesting solutions that are coming up in terms of dealing with things like smart contracts and how many things can be automated. For example, recently the UK Law Society, it's called the SRA, so they are the ones who regulate law firms and solicitors in England and Wales. They had given an authorization to an AI law firm,
okay,
and the point of this law firm is it can help you recover smaller debts. And what that would
okay,
mean is that you would upload your contract, or you would upload whatever documents that you have. And on your, based on your documents, it will prepare like an initial draft, and it will send
okay,
that draft to the other side as a letter of notice, as a legal notice
okay,
to the other side. And then, assuming that there is no response from the other side or it needs to go to court, then if it's then it will also like draft like an initial petition for you. I have not used this aspect before, and but it's so
okay.
interesting, and I'm genuinely fascinated
Right, right,
because I mean, there's times where there are smaller debts, and you don't necessarily know if a law firm would be right for you.
right.
And having having access, especially for something like consumer disputes, where you might have an issue with a very small value item and you want remedies, but you don't necessarily want to incur legal costs.
Spend too much
So
of time on it. Yeah,
there is a lot of evolution happening in that sense, where people are trying to think about how we can reduce the kind of costs that people go through, and also at the same time increase the access to information that non-lawyers can have, that clients can have, so that if there are simpler issues, smaller issues, they don't have to worry about it. Although, I mean, that wouldn't necessarily apply in the case of smart contracts, because if they are
Yeah.
specialized parties who are dealing with smart contracts, then
Right.
I recommend that it's best to have legal advice in terms of what to do in the case of a breach.
Okay. In closing, Tanya, can you talk of, let's say, somebody who's interested in arbitration? I think you've done a wonderful job by uh, narrating your own personal experience and ensuring that that is the kind of preparation that people would do well to follow in order to build their career. Do you have something that you feel requires a certain kind of temperament? What would
I
your advice be?
with an arbitration career, generally I think with a career in law, there needs to be a certain element of curiosity where when you see differences in whether it's in terms of culture, in terms of strategy, in terms of opinions, there needs to be an element of curiosity that you lead with, because it's so easy to say that, my way is the right way to do things and your way is the wrong way to do things, right? And I think leading with curiosity has served me so well in my career, because I often put myself in the shoes of the other side and think about why are they doing what they're doing, which is what also informs my legal strategy and makes me a better lawyer on every matter that I'm working with. Because everyone is doing something because they think it's the right thing for them to do. And that element of curiosity is something that I would recommend that everybody nurtures if you are interested in arbitration, because you deal with differences far too often. But beyond this, obviously, there's a certain amount of work ethic that you need in terms of going through those long hours and dealing with people. I think it's also an element of personality where you need to be able to work with people from different backgrounds and collaborate with them, because we don't just work with lawyers, we also work with expert witnesses. We also often work with general fact witnesses who might be employees of the company. So, finding a way to break down complex topics into simple ideas can be quite an asset in international arbitration as well.
Great. On that note, I think we'll leave it there because it's been such an interesting uh, understanding of what you do on a daily basis and how your career is at this point, Tanya. Thank you for taking the time and you know being so articulate about what the profession involves, what the future involves, and what kind of qualities you require to succeed in this profession.
Thank you so much, Venu. It was so nice of you to invite me over here, and it was such a pleasure to share my experience. I really enjoyed this experience, and I hope that you continue to do what you do, because I'm such a fan of your podcast.
Wonderful. Thank you very much, Tanya. That was Tania Singla, and she spoke wonderfully about what it means to have a career in arbitration. Next week, another guest, another career. Until then, keep watching.